commemoration of the World Refugee Day, which was held yesterday, 20th June. In commemoration of the World Refugee Day, we are organizing this national webinar titled as the Global Compact on Refugees and how it influences the laws, policies, and practices in India. This is in terms of showing our solidarity to the refugees worldwide and understand the very phenomenon and what are the related issues and how practically we will be able to understand and work towards addressing this important issue of the global refugee crisis. In this endeavor, we have the Tata Institute of Social Sciences, the Vellore Institute of Technology, Andhra Pradesh School of Law, and UNHCR India partnering and conducting this national webinar. A very warm welcome to all the participants. We know that we have a capacity of 100 and the numbers have increased. We would like to inform you that there is a YouTube live link. Kindly, those of you who are present here, share the link to others, your friends and others who may be waiting. Kindly share it so that they'll be able to join us on the live tube. We will see what way we could accommodate the other numbers in case of any technical thing which we could resolve and increase the numbers. We will see that. With that brief note, I now welcome all the panelists in the inaugural session out here. I'd like to invite Professor Banerjee Chaka, who is the Dean of VIT AP, to provide the welcome address. Later, we will be having ourselves the Ms. Yukiko Koyama from UNHCR India New Delhi office, who will be providing us the inaugural address. Following which we will have the Vice Chancellor of VIT AP, Professor Reddy, and Professor Tiwari, who is the Dean of the School of Law, Rights and Constitutional Governance, Tata Institute of Social Sciences, will provide us the presidential address. So this is the panel we have for the inaugural. We have Professor Samir Das, who is from Kolkata University and former Vice Chancellor of North Bengal University, will be providing us the keynote address. So we very warm welcome to all the panelists. Now I invite Professor Banerjee to start with the formal welcome note. Over to you, Dr. Banerjee.
Thank you, Dr. Pari, and a happy morning to all of you. On the occasion of World Refugee Day, which is being celebrated across the world on 20th of June, to realize and ask ourselves to remind towards the basic obligations of Refugee Convention of 1951 and its protocols, and the obligations which are there as a part of the Global Compact Refugees. At the outset, when we are celebrating this important occasion, we will have to look at it, what obligations in the states have, civil society, as well as academia. And in order to reflect the opinions which we have, today, the VIT AP School of Law, in collaboration with Tata Institute of Social Studies and UNHCR, which is a nodal agency to protect the refugee mechanisms and to provide all the durable solutions, are here to reflect upon the important milestones which we have and the work to be done in coming days. I'm sure that this particular platform will deliberate upon very important things. And I'm happy to inform that we have expert panelists and we have erudite scholars which are lined up today. And I welcome on behalf of organizing committee, all these speakers, experts, and people from civil society. I take this opportunity warmly welcome Ms. Yukiko Koyama, the Senior Protection Officer of UNHCR India New Delhi, for her presence and for her time and for her commitment towards the refugee protection in this country and South Asia. And I also take this opportunity to thank and invite Professor Samir Kumar Das, a professor, Department of Science, Political Science, Calcutta University, and a former University Vice Chancellor of North Bengal. And Professor Samir Das sir is one of the renowned scholars of refugee law in this country. And I take this opportunity to invite and welcome Professor Dr. Arvind Tiwari, Dean and Professor of Law at School of Law, Rights and Constitutional Governance, Tata Institute of Social Studies. And I also take this opportunity to welcome my own friend, Dr. K.M. Parivalan, Chairperson, Center for Refugee and Statelessness Studies, TIS Mumbai. And apart from that, I welcome all the scholars and all the people, those who are showing very much interest to join in this program. I also could see that there are people from civil society, academia, particularly people from the Bangalore University and other university across. I warmly welcome them all. And indeed, today it is going to be one of the good occasion and where it is UNHCR and VIT School of Law have joined together in order to provide a debate about how this global compact on refugees is going to provide a mechanisms for the purposes of providing policy guidelines, legal framework, and a practical orientation and what we have on this. With these few words, once again, I warmly welcome all the participants, dignitaries, scholars, and professors and civil society to this important event which we are celebrating. Thank you very much.
Thank you, Dr. Banerjee. Brief introduction about Dr. Banerjee, which I think missed out. He's currently the Dean and Professor of Law at the VIT. He has his PhD in International Law from Jawaharlal Nehru University, New Delhi, India. He served as Associate Professor of Law and Registrar of National Law University and Judicial Academy, Assam, and the Lecturer of School of Law, National University of Ireland, Galway, and worked as a legal advisor to the International Committee of Red Cross Regional Delegation of South Asia. He has several publications and conducted several conferences and seminars. With a brief note of Dr. Banerjee, now I would like to move on and invite Professor Arvind Tiwari, who is the Dean of the School of Law, Rights and Constitutional Governance, Tata Institute of Social Sciences, Mumbai. A brief introduction about him. He serves also as a chairperson of Center for Police Studies and Public Security. He has done his PhD in Criminology and Forensic Sciences from Sagar University. He has served in several capacities with the National Human Rights Commission earlier and currently as a professor. He's been in several panels with several publications and several portfolios within TISS. He has served as Dean of Student Affairs earlier, and currently he's the Dean of School of Law, Rights and Constitutional Governance. I invite him to provide a brief presidential address, please.
Thank you, Dr. Parivalan, and good morning to all of you. At the outset, I would like to congratulate and greetings to all of us for World Refugees Day and International Yoga Day. This is the double occasion for us to meet today and celebrate the World Refugees Day. You see, the topic and the area which has been selected by my colleague and the other partner institutions is very, very relevant in the contemporary context. As we all know, that refugees problem is a very humanitarian problem across the world, and several peoples are being displaced because of the internal conflict or the other kind of militarization and other situations which are prevailing in various countries. And people are suffering, the women, the children, and this is a very serious humanitarian crisis before the humanity. and all countries together. As per you see the data by UNSCR, you see the theme which has been selected by UNSCR is the World Refugee Day is focus on the power of inclusion. And the whole purpose is together we can achieve anything. So that means we all civil society, as Dr. Banerjee has also uh, uh, said, that you see here we are having representation from the academia, civil society organization, UNSCR, and our partners. So this is a very good occasion for us that let us deliberate this issue. And particularly this COVID-19 situation has also complicated this issue. And several people, like according to UNHCR data, every minute 20 people leave everything behind to escape war, persecution, or terror. There are several types of forcibly displaced persons: the refugees, asylum seekers, internally displaced persons, stateless persons, returnees. So these are various kind of you see people, those who are suffering, and they are covered under several categories. Now, as we all are aware, that 1951 Refugee Convention and its 1967 protocol give the protection to these people. But despite that, several difficulties are faced by the stateless people and the refugees. And I will not go because detail, because Dr. Parivelan would be analyzing the situation and telling us the whole scenario. So the 1951 convention gives the several kind of rights to these people, refugees. The right not to be expelled except under certain strictly defined conditions, the right not to be punished for illegally entry into the territory of contracting state, right to work, right to housing, right to education, several kind, access to courts, etc. So these rights are already there, but countries, according to their constitutional and the legal framework, they deal with this. And the Global Compact on Refugees in fostering laws, policy, and practices also reiterate that the asylum seekers or the refugees should be given protection. And the UN General Assembly adopted the New York Declaration for this. And almost all member countries have agreed to this. In 2018, you see, UN General Assembly affirmed the Global Compact on Refugees during 2018 with participation of many nation states and civil society organizations. So, therefore, the Global Compact constitutes an important body of international law governing the protection of migrants and refugees. So, this means that the solution has to be found out within the national constitution and the laws and policies, and how to strengthen the legal framework for refugees so they can get their rights, because there are both kind of debates. One is this, the national resources and the issues pertaining to the refugees in the local population versus also their rights and international law. So I think during academic debates, and I'm sure that this one day seminar, webinar rather, nowadays we are in webinar mode and not in seminar. So I hope that after some time we will be meeting as a seminar somewhere. So this is giving us a very good opportunity to discuss and deliberate the issues, the legal framework, the roadblocks in that, and how we can find out the durable solutions according to the constitutional and legal framework of our country, if we are saying with context to our country. Regarding this, the center which Dr. Parivelan is heading is the Center for Statelessness and Refugee Studies. Although in number, we are a small center in the school, but still the efforts are always made by my colleague and other colleagues also. How to strengthen it, and to explore the possibilities to do some empirical studies and also have liaison with the UNSCR. With the UNSCR, we have the LOR. And also, now I would urge the representatives of UNSCR and other partnering institutions that let us also explore and see the possibility for future collaboration. We can identify some kind of activities within the time frame, some time limit we can give, and let us see how we can work together and also show our solidarity with the issue, as well as some kind of evidence-based kind of research, as well as like law school. We have been deliberating with the UNSCR representatives and within our school that let us also engage with the other law schools and other universities also, those who are teaching law or international human rights or humanitarian law, and also with the civil society partners, as well as with the state representatives, the criminal justice system and other associated agencies of the state. Let us explore the possibilities and let us have develop some kind of protocol and collaboration which will show us the path for the future evidence-based research studies and seminar and webinar and some kind of documentation which we can submit to and share with the all stakeholders in the society. I'm sure that this deliberation, one day deliberation, because the representation which I have seen and I see now is a very wide. And there are academia, there are top scholars from various universities. Professor Samir Kumar Das is there, Miss Yukiko Koyama is also there from UNSCR, who is the senior protection officer, and galaxy of the academia representative from the civil society and our students also. Some of them I could see on the screen. So this is a very good opportunity for all of us to collaborate academically and also find out and some kind of actionable. I would urge the seminar organizers and all the participants, let us come out with some kind of actionable recommendation and some kind of way forward, how we can move after this webinar, and which could be done either individually or by the institutions which are collaborating or sometime collectively, so that we can help the refugees and we can also address legally and within the constitutional framework the problem of statelessness and refugees. So once again, I congratulate all the partner institutions and also all the experts and VIT colleagues and Professor Das and UNSCR, and finally to my colleague Dr. Parivelan, who is always active and who is proactive in this, that how to collaborate and organize different kind of activities and do the evidence-based research. So I congratulate all of you and to my colleagues, Dr. Parivelan and my other colleagues, all the best from my side. Director could not participate in this program because she was having some other commitment. But on behalf of the Institute, I welcome once again to all of you, and I hope that we will come out with some kind of actionable recommendation which could be within the legal framework and the constitutional framework. Thank you very much.
Thank you indeed, Professor Arvind Tiwari for providing an excellent outline of the webinar in terms of what kind of a focus we can have towards refugee protection and the obligation to take care of refugees in a legal sense, in a policy sense and practical sense. Thank you for your kind words and wishes. We all know that this year's theme of the World Refugee Day is to heal, to learn, and to shine. This is the theme, which means that we need to kind of make an inclusive approach to have the refugees on board who have faced crises, who have crossed international borders, and it has become a kind of an obligation of a kind of a responsibility sharing mechanism. So how does the legal regime work? How do we take care of it is a very huge challenge, which we are going to deliberate further. But keeping the theme, to heal, to learn and shine, and how does our refugee compact emerge, and how that's a kind of a framework on which now the governments and civil society organizations, private sectors and others are fostering the cooperation globally. To provide that perspective, we invite now Ms. Yukiko Paema from UNHCR. Ms. Yukiko is the Senior Protection Officer at the UNHCR India office at New Delhi since 2018. She has worked in around 6 countries around the world in various capacities within UNHCR, has a very wide and very rich experience. Since 2005, she has been serving with UNHCR, and I have personally interacted with her on many occasions. A very proactive person, very encouraging to bring academic institutions and various stakeholders together. She has been playing a very pivotal role as a senior protection officer on different occasions we had seen. It is extremely a great pleasure for us to have her to have UNHCR as a partner in this very webinar, and to have her as a guest here, and who will provide us the inaugural address. Now over to you, Ms. Yukiko.
Thank you very much, Dr. Paribalan, for the kind introduction. And good morning to all of you and distinguished guests, ladies and gentlemen. I would like to thank you for the opportunity and for the UNHCR to join the national webinar, and Dr. Paribalan and all that the institute. And this webinar, as mentioned earlier, jointly organized by the School of Law, BITAP, Center for the Statelessness and then Refugee Studies, School of Law, Rights and Constitutional Governance of TIS, and then UNHCR India. I'm happy to hear already several times about the World Refugee Day. The 20th of June, yesterday, was the World Refugee Day, which we have commemorated every year. This year, our core message is that together with refugees, we can achieve anything. Together, we heal, learn, and shine. Under this theme, UNHCR calls for the greater inclusion of refugees in health, education, and sport. The shared experience of the pandemic has shown us that we only succeed if we stand together. I'd like to echo the words used by the High Commissioner for Refugees in his statement for the occasion of the World Refugee Day. He said, on World Refugee Day, as we pause to express solidarity with refugees in our communities and around the world, we hope each of us will also acknowledge and admire the drive, determination, and contribution made by people forced to flee. My colleagues and I have the privilege to witnessing their tenacity and achievement every day, which should be the source of inspiration for everybody, everywhere. It's a great pleasure for me and for UNHCR to be with you today. And then we have such a privilege to also deliver the speech on this occasion after we commemorate the World Refugee Day yesterday. And then we hope to shed a light on the refugees and their resilience and call for the solidarity. Last week, UNHCR published the latest annual global trend report. The number of the people fleeing the war, violence, persecution, and human rights violation in 2020 last year increased to nearly 82.4 million people. This is a 4% increase on the top of the already record high number of the displaced population at the end of 2019. 20.7 millions are refugees under UNHCR mandate. 5.7 millions are Palestine refugees. 3.9 millions are Venezuelans displaced abroad. Another 48 million people are internally displaced. And then further 4.1 million were asylum seekers. These numbers indicate that despite the pandemic and also the cause for the global ceasefire, conflict continued to displace people from their homes. Today's national webinar focusing on the Global Compact on the Refugees. The Global Compact on Refugee is a framework for more predictable and equitable responsibility sharing. This is because a sustainable solution to refugee situation cannot be achieved without international cooperation. The Global Compact on the Refugee provides a blueprint for governments, international organizations, and also other stakeholders to ensure that host communities get the support they need, and then refugees can lead a productive lives. The Global Compact Refugee also constitutes a unique opportunity to transform the way the world responds to the refugee situation, benefiting both refugees and then also host communities. The Compact has the 4 key objectives. 1, ease the pressure on host countries. 2, enhance the refugees' self-reliance. 3, expand access to the third country solutions. 4, support the condition in country of origin for return in safety and dignity. The COVID-19 pandemic has deeply tested global commitment to protecting refugees. But at the same time, it has also shown the value of including refugees in national responses and safety nets to benefit of all. The pandemic has shown us the importance of working together, the importance of shared responsibility, and the importance of the need to ensure that health and other social services meets the needs of all of us. The virus does not discriminate whether you are national of the country or refugees. Whether you are national of the country or refugees, access to the health services are very, very important. The pandemic impacted refugees socially and economically, as the refugees often depending on the informal sector, they were among those who suffered the economic impacts of the lockdown, losing their livelihood opportunities, and then also being at risk of eviction from their homes. It has been reported globally that refugee students, many of them are girls, have difficulty in accessing the continuous learning during the pandemic period. So after the reopening of schools, there was a great concern that refugee children may drop out from the schools, and then progress made so far might be lost. Also globally, the number of the third country resettlement for the vulnerable refugees to the new country decreased due to the COVID-related restriction. Therefore, the UNHCR and its colleagues are exploring every possibility to expand resettlement and other third country solutions, including the complementary pathways to the third country. And in terms of the solution, preferred option for the many refugees is to return to their home country when conditions allow. However, for many protracted situations, returns are still difficult at the situation of the country of origin are not yet conducive for safe and sustainable return. The pandemic has added new challenges to the voluntary repatriation. Against such backgrounds, it's really important for us to focus on the inclusion of refugees in their host countries, including their social services, education system, and also the livelihood opportunities. The inclusion of refugees in the host countries mean that hosts must be also supported by the international community. We know that pandemic will affect all of us. We can no longer exclude the people on the basis of their legal status, and we should continuously work for the inclusion and share the responsibility. In India, as we explained the difficult period of especially the second wave of the COVID pandemic, we applaud that inclusive approach of the government in India, especially to its vaccination campaign. As a result, the vaccination drives for refugees are happening in the different parts of the country, which gives the hope to the refugee in India after challenging times. Also in India, it has been observed that many refugees mobilized to support their own communities and then also the Indian neighbors. There are refugees who tirelessly serve as a frontline health workers. Others also cooked meals, made face masks, helped with the distribution of the food and non-food items, sanitary items to the needy families. And then also there are refugees who facilitate the continuous remote learning for the refugee children. And also there are refugees who look after the most vulnerable, both refugees and also the members of the local Indian community. We also celebrate the host communities who welcome those seeking safety and protection in India by sharing whatever they have with their new guests. India and Indian people have hosted and protected refugees for the generations. Continuing to uphold these values in the time of the pandemic is a powerful message of hope and then also solidarity. On the World Refugee Day, we celebrate the resilience and dedication of such many refugees and asylum seekers in India who have addressed the challenges posed by the pandemic. We also continue to work with the various stakeholders, including other UN agencies, civil societies, university, academics, students, researchers, private sectors, to support the Indian people and the government to protect and assist the people seeking safety in the country and to ensure that no one is left behind in line with the Sustainable Development Goal. We'd like to take this opportunity to express our appreciation to various countries, companies, organizations, individuals, academia, students, the civil societies, NGOs who joined us in a spirit of solidarity, giving us resources to address the most urgent needs. These values of inclusion and solidarity with refugees and the whole of society approach were enshrined in the Global Compact on Refugees, which we will discuss today through the webinar. We call on all to seize this opportunity to continue building a more inclusive society for all, including refugees who came to India seeking protection and safety. I wish you all the best to today's national webinar participated by the various stakeholders. And thank you very much once again for this opportunity and to be part of the national webinar. Thank you so much.
Thank you very much indeed, Ms. Yukiko, for providing a wonderful inaugural address covering the UNHCR perspective of how we are moving into this era where there is an unprecedented numbers of nearly 82 million plus population, which is a tremendous increase, and the COVID as a context, which is compounding the pressure. You very well highlighted the responsibility sharing. You highlighted the whole of society approach, and also to leave no one behind, which is an important sustainable development goal globally, all of us are adopting. I think these all remain a framework to make things more inclusive, to address the very theme of heal, learn, and shine. How do we work? I think we have highlighted all these very important points, which will form as a framework for today's deliberations as well. Thank you once again, Ms. Igiko, for providing a very concise and crisp inaugural presentation. Now we will move to invite Professor Samir Kumar Das as for the keynote address. A brief introduction I would like to provide. Personally, I have been interacting with him for almost now about 16, 17 years, since 2004. He's been a good friend and a mentor as well. In a personal note, I'm very happy to have him here for the keynote address in our inaugural session. Professor Samir Kumar Das is currently the Professor of Political Science and also the Director of the Institute of Foreign Policy Studies at University of Kolkata. Formerly, he served as a Vice Chancellor of University of North Bengal and Dean, Faculty of Arts, University of Kolkata, an adjunct professor of the School of Foreign Service, Georgetown University. He is currently the coordinator of University Grants Commission Department Research Support Program on Democratic Governance. He has a postdoctoral fellowship in 2005 from the Social Science Research Council South Asia program based at New York. He specializes in rights on themes like ethnicity, security, migration, rights, justice, democracy, and lectured widely in premier academic institutions in USA, Finland, France, Italy, Sweden, Belgium, and other countries. He has published many pertinent articles and books on forced migration and on refugees, which some of them we have been reading and referring in our curriculum as a reference text. It is indeed a very honor and pleasure to have Professor Samir Das to deliver us the keynote address. Over to you, Professor. Professor Samir Das.
Thank you, Parivelan, Madam Koyama, Professor Tiwari, Dr. Banerjee Chakka, and my dear friend, Dr. Parivelan.
Sir, sorry to interrupt. Can we switch on your video if it is possible? I think we are missing out on the video front. From the technical team also kindly assist in the video, please. Professor
No,
Samir.
I have switched on my video. Maybe that you are unable to see me.
Okay,
maybe
okay.
there is problem at my end, but let's
No problem,
hope that
so
I
please
appear on the video. But
Yes.
on my screen, I can see myself. Anyway.
Okay.
Members of the august audience, and most importantly, my dear students. I begin with a word of thanks to Center for Statelessness and Refugee Studies, School of Law, Rights and Constitutional Governance, TISS, to School of Law, VIT, AP, UNHCR India, and Dr. Parivelan in particular for giving me the opportunity of delivering the keynote address. Let me at the outset put on record that I feel deeply honored by this invitation. With a word of caution though, what I'm going to present is still a work in progress, and it is in webinars like this that we get an opportunity of tossing around our yet unfinished and uncut ideas, learned from the students, colleagues, and members of the august audience. Now, what I'm going to present today might not be exactly to be classified under refugee law, but at best it will be an exercise in the anthropology of law or legal anthropology. The theme of this year's World Refugee Day is Together We Learn, Together We Heal, Learn, and Shine. Never before in our lifetime has healing acquired so much of importance as it has now in the context of this deadly and lingering pandemic. While UNHCR and other UN documents have been persistently highlighting the importance of coming and remaining together in this context, mark this word together, I will in course of my address try to draw your attention to some of the challenges in the light of a few of our recently conducted ethnographies and argue that coming and remaining together turn out to be a daunting task and call for a more nuanced policy intervention than what we see today. Honorable Dean has highlighted the importance of finding out actionable alternatives. Maybe that this is a small, modest step towards the finding out of actionable alternatives. Let me preface my address with an account of how the term together is deployed in these documents, I mean UN and UNHCR documents, and how it marks a departure in global responses, at least in three different senses. First of all, the term together forces us to question the commonly made distinction between the citizens on one hand and the migrants and refugees on the other. One of the UNHCR documents, for instance, reminds us, quote, as the virus can affect people of any nationality or status, mark this word status, broad-based inclusion efforts are only one way to contain its spread effectively and protect the health of refugees and host communities, unquote. The malevolent virus and its volatile movement cut across communities, countries, and regions and blur the distinction between the citizens, migrants, and refugees. Secondly, togetherness implies the migrants and refugees must not be treated as a separate entity waiting for a separate response. Parallel to the general social and economic policies of the host country, in fact, UN documents warn us against sticking to a parallel approach towards the refugees. It means that the whole of government and whole of society responses must complement efforts in the health and other sectors in line with the Global Compact on Refugees, GCR. The documents urge civil society groups, INGOs, NGOs, voluntary initiatives, development actors, private sector, community-led organizations, and faith-based groups to be part of these efforts, of course, under the umbrella of national laws and policies. Thirdly, healing under conditions of pandemic is too serious a matter to be left as a humanitarian duty that may be performed at one's own sweet will. It is now in the interest, mark this word interest, of everyone to come and remain together so that an organized and holistic response becomes possible. And then I quote a UNHCR document, quote, when considering the possible wider impacts of an outbreak of infection in host communities, support to refugee camp or settlement and their hosts, or to refugees in urban settings is not only a duty, but also in everyone's interest. No one can be truly safe until everyone is safe, unquote. Please allow me to begin with an anecdote. Just on the eve of the lockdown, one of my students proposed to me that he would work with me on manual scavenging and manual scavengers of one of the neighboring districts of Kolkata. Interestingly, about 50% of them, as per his sample, have reportedly migrated from Bangladesh. None of them, surprisingly, belongs to the traditionally known caste of manual scavengers. In fact, most of them are not Hindus at all, although they live together under the same roof in hired accommodation. Their desperate economic conditions have led them to take up this profession in an alien land. They keep their profession a closely guarded secret even to their own family members for fear of stigmatization back home. One of them, in fact, said that people feel like vomiting on us if they hear that we are manual scavengers. As we probe this example a bit more closely, we are confronted with a paradox. On the one hand, the very presence of this group of manual scavengers is emblematic of at least three illegalities. First, 50% of the manual scavengers that my student has been interacting with are Bangladeshis, quote unquote, who had illegally migrated to the district town, apparently without carrying necessary travel documents. So their presence in India is ab initio illegal. Secondly, many of them confessed to him in confidence that they had, quote, criminal records in their home country, and they had escaped to India in order to avoid police dragnet. Thirdly, they are connected to a profession that was rendered illegal by the Prohibition of Employment as Manual Scavengers and the Rehabilitation Act of 2013 that put an end to the practice in India. On the other hand, it is difficult to believe that the police are unaware of their presence in the district town. Then why are they not detained, arrested, tried in a court of law, convicted, and punished if the rule of law is considered as the defining principle of the normal condition of life? Mark this word, normal. The policemen do not stop them from working as manual scavengers on the ground that people in these areas who continue to use kacha latrines are in dire need of their labor, will be in distress, and all this might lead to a great public health disaster. In other words, what we understand as normal condition of life, mark this word, normal, can be maintained not by strictly observing the law. In fact, if you strictly observe the law, the normal condition of life, public health cannot be maintained. But only the normal condition can be maintained only by way of allowing its imperceptible breach and violation. You allow violation to take place, and you turn your eyes away from it. I noted with great surprise how this breach is absolutely essential for maintaining the normal life conditions in the town. In other words, the legal is not necessarily normal. Everything was normal till my student reported that way back in April 2020, the elbow of one of the manual scavengers was broken by the police when he came out to buy some essential items from a nearby grocer's shop and look for a job, breaking evidently the strict nationwide lockdown that was then in force. Like thousands of others, he too came out when he found it impossible to remain confined to home without a job. The theoretical cue of this argument draws on Georges Canguilhem, his book, The Normal and the Pathological, who cautioned us against taking the normal as the opposite of the pathological. For the normal calls for our ability to adapt to the fluctuations in the social environment by bending or breaking the laws, as in this case. The virus, however, introduces a radical change in the scenario, for it implies our reduced ability to adapt to the fluctuations in the environment. The disease demands that the law that separates the normal from the pathological, our healthy bodies from the virus-carrying bodies, must be neither bent nor broken, but will have to be strictly enforced. Now, this is the time when you need to enforce the law, because you can't allow the normal to mix with the abnormal, the disease. We have to ensure that the virus is completely isolated and the deadly pathogen is not allowed to mix with the normal. So those who are suspected to bear the virus in their bodies, the immigrant manual scavengers or the stranded workers or the refugees, must not be allowed to come out and infect us. Therefore, at that moment, the divide between the normal and the pathological is at their widest. Surfacing the virus-carrying bodies of the migrant workers is the last thing that the police could allow and tolerate. So their elbows are broken, and the low-wage workers are fired upon when they crowd in Bandra bus terminus, in Badarpur border in Delhi, or railway station in Surat, desperate to take the next vehicle for return. Separating the normal from the pathological is supposed to serve what is called the public good. Now, I'm still continuing with the theme of togetherness, and I try to argue that how problematic this theme of togetherness might be. For keeping the two separate, meaning the normal from the pathological, is considered as a sine qua non of maintaining public health, at least in two senses of the term. First, public health is indivisible. It is not enough that I or my family remains safe. It is as much important to isolate every single member of my neighborhood and nation from the virus so that my family and I stay safe. In other words, my family and I have a stake in the safety of others. Secondly, one man's entitlement to safety does not in any way diminish another man's entitlement to the same. They are not only non-rivalrous, but are in fact complementary to each other. Take mask refusal as an example. Now, every day you are being shown that people are not caring for masking. Masking is considered as one of the three principles of maintaining public health in times of pandemic, besides social distancing and hand sanitization. A team of my students recently conducted a study on a sample of over 100 respondents in order to figure out what they might think about the prescription of universal masking. About 18% do not know how important universal masking is in maintaining public health under present conditions. Roughly about 77% do not think that wearing masks by them will make any difference, though some of them grudgingly wear them out of compulsion. Why are they so much averse to the prescription? Interestingly, the arguments they offer shuttle between two extremes. One, wearing mask does not make any difference to one when one knows that one is not infected and everyone else in the society wears it. One chooses to be a free rider, enjoy all the benefits of masking without wearing one and sharing the cost. Sometimes the argument is turned upside down, and we are told if no one else is wearing it in the society, then it will not make any difference if one alone wears it, pay the cost and bear the pain. It's like arguing that why should I suffer for a gain that will benefit all? In economic theory, this is called the public good dilemma. In other words, rules of sanitization, masking, and social distancing, in short, SMS, will not be ordinarily observed unless the state or the society enforces it and compels us to do so with the threat of some form of sanctions. When influenza and SARS broke out in the United States in the early years of this new millennium, Ronald J. Glasser, he was at that time the Surgeon General, wrote, quote, "The idea of common good has disappeared from our national consciousness, giving way to the misconception that we no longer need concern ourselves with the welfare of our fellow citizens. It is a dangerous conceit, and it leads us toward a future infected with unprecedented and unnecessary disease." The absence of public good perspective sets in motion a series of perpetually shrinking concentric circles, and togetherness takes a backseat. Our concern for being safe continuously closes in on itself. If we cannot keep the nation, state, or neighborhood safe, then we need to keep our home safe. We have examples of infected neighbors being turned out of the locality and were seen to be wandering aimlessly till they were detected by the police or health workers. If we cannot keep our family safe, we need to keep ourselves safe. Again, we have examples of elderly persons turned out of their homes on the suspicion of having contracted the virus and running temperature in their bodies. More often than not, fear from the virus revives and reinforces the pre-existing social cleavages and takes on a racist character. The migrant scavengers were not allowed to come out during the nationwide blackdown nationwide lockdown, while the police appeared to be reluctant to enforce laws during the normal conditions. While the migrant workers are perceived as a threat whose bodies must be bared and disinfected with lethal pesticide and spray, and this happened in one of the borders with Uttar Pradesh, the nurses from India's northeast serving in the hospitals of Kolkata become objects of hate speech and racist attack. Tibetan refugees are easily mistaken as Chinese, where the pathogen originated, and are abusively called corona and are harassed. If togetherness of a public good perspective does not drop from the blue and is to be enforced by the state, where was the state to be seen? Early in the morning on 25 March 2020, when a reporter visited one interstate border of Delhi, she discovered thousands of stranded workers swarming around, desperate to return home, significantly without any trace of policemen or state administration. For these desperate workers, the state simply withered away. The SWAN, I guess the full form of SWAN is Stranded Workers Action Network, survey tells us that 96% of the stranded workers had not received rations from the government during the initial days of lockdown, and 70% of the sample had not received any cooked food. The government, by its own admission, does not have any record whatsoever of the number of the migrant workers or the deaths during lockdown, whether in road and railway accidents or due to starvation, fatigue, and overexhaustion, or otherwise while undertaking their long journeys, sometimes stretching over 1,000 kilometers. In simple terms, this made social governance all the more necessary. So in other words, what do you do when, for instance, things which ought to be done by the state agencies, whether in India or elsewhere, I describe it as social governance. Much of the burden of migrant workers under conditions of pandemic is now made out to be the responsibility of the society, not the state. This could happen, I will argue, wherever there is sociality and people's association with their home, household, neighborhood, or community is strong, and there is a strong support system existing in the society. We have reports of communities living in the remote villages enforcing lockdown and quarantining independently of the mediation of the state. Churches, crematoriums, local clubs, tree houses, floating boats, and community dormitories were specially earmarked as the quarantine centers. In Nagaland, village elders who are custodians of customary laws are leading the community surveillance program. In Mizoram, people in Champhai and Serchit have given community policing an international touch. Such organizations as Naga Hoho in Nagaland and in the hills of Manipur, Meirapai Bees in the Imphal Valley, Mizo Zirai Paul, Young Mizo Association, LLTF, or local level task force, formed in every locality in Mizoram, Mukti Sangho in Tripura, played an important role in exercising surveillance, quarantining the outsiders, detecting and isolating the infected, helping the infected with medical assistance, and so forth. If village vigilantism is the first mode of social governance, trust constitutes the second mode. One reason why shops selling essential provisions were asked to close down during the nationwide lockdown is that any form of transaction would require the meeting of the buyers and the sellers physically, thereby exposing one to the other with a high risk of the spread of the virus. Is any transaction possible without the two physically meeting each other than online transactions that are nearly impossible in remote areas where internet reach is either poor or simply non-existent? I wonder. States like Manipur and Mizoram gained from a traditional method based on trust, followed in shops. Even if shops are unmanned, people pick up what they want and put the money into a cash jar. This has fortuitously contributed to social distancing. The community served as a collateral in all these transactions. Let me now sum up. On the one hand, pandemic not only poses a threat to life, but effectively cuts into our ability to remain and respond together at a time when the need for remaining and responding together is perhaps at its highest. So I thank UN and other multilateral agencies for having drawn our attention to the importance of remaining together. But remaining together at the time of pandemic is perhaps the most challenging of all tasks. Our responses are seldom informed by a public good perspective. On the other hand, this togetherness does not exist out there, does not drop from the blue, but will have to be brought from outside. While the state is best suited to bring about this, the task is passed on to the society. The society responds wherever it can, it does not wherever it cannot. It is this melee that our public health policies need to address. Thank you very much for your patience. Thank you.
Thank you very much, Professor, for your wonderful keynote address outlining the importance of refugee protection, refugee responsibility sharing, starting from the very interconnection between the refugee crisis and the current ongoing COVID pandemic, and how there is an interface between the refugee protection and pandemics in terms of the normal and pathology as a kind of dynamics. You explained it well and talked about the public good dilemma for both health as well as addressing the issue of the refugees. Very, very touching and very pertinent observations you have made, outlining the importance for this very national webinar. Our heartfelt thanks from all of us from the organizing team of TISS, UNHCR and School of Law, PITAP, profoundly for providing us the keynote address. Thank you so much. Now we will go to the next item, that is a brief overview of the webinar. And of course, I will also propose a vote of thanks now. Well, one is, of course, the World Refugee Day as a context. We have, of course, and we have done this last year as well in a collaborative manner. And it is not supposed to be just a ceremonial one, but indeed just to make us think, reflect on this very day when there is a global celebration of World Refugee Day on 20th of June. We are thinking that we should, definitely come and reflect it, express our solidarity, have a webinar in a way that we have all stakeholders coming in, not just merely the students, research scholars, faculty members, but also to bring on board some of the practitioners, some of the people from civil society. That's how we have conceptualized it, actually, that how, the framework, as it has been highlighted by the speakers, that we have a refugee crisis right from the days of the World War II and the emergence of the 1951 Convention on the Status of Refugees and 1967 protocol. This remains the kind of a legal framework. But in the history, there have been always displacement, movement of people, and there have been ways and means in which we've been addressing it. It's not something very new. And we all know ourselves the backdrop of within Indian experience, where during the partition alone, almost around 14 million people were displaced across, and we have had those kind of management of addressing that kind of a displacement. We have had the 1971 Bangladeshi, Pakistan and Bangladeshi crisis, which triggered a huge refugee movement. We have had the Sri Lankan refugees since 1983, The ethnic crisis in Sri Lanka led to a displacement of a lot of refugees into India. We have had the Chin refugees from Myanmar earlier, now from the Rohingyas from the very Myanmar have been here for quite some time. We have had the Afghan refugees and so on and so forth. We have a range of them here in our country. So our thinking is that what we have been doing in terms of, India is not signatory to the conventions and protocol. And we do have a kind of an ad hoc policy in terms of, doing it, where precisely a term being used that we need to balance between the national security and the humanitarian and the human rights of the refugees. Precisely the words of judiciary in the recent time. I think that is a kind of a falcon we have, that how do we balance this? So therefore, even in conceptualizing this webinar, we have 2-3 experts who will speak from the national security, national interest perspective. At the same time, we have a number of other speakers who are going to speak on the range of perspectives on refugees, gender perspective, their political, socio-economic and cultural rights perspective, all that we have. So we have speakers who are from UNHCR, South Asian University, Delhi University, Calcutta University, National Law University, Law Institute University, Bhopal, Loyola College, Madras Christian College, Jain deemed to be university. Several civil society organization representatives are here today, ranging from Oxfam, Save the Children, Catholic Relief Services, Jesuit Refugee Services, and so on and so forth. So we are going to have a wonderful mix of academics and practitioners who are working. I thought it's very important for us to get the practical perspective. And we have, of course, participants from wide-ranging arena of students, research scholars, faculties, NGOs, think tanks, and all that wider thing. As it has been highlighted, now the refugee numbers in terms of the forced migration has crossed almost 82 million, according to UNHCR recent report, which is a matter of concern. And it's very important for us to, understand and distinguish who is a refugee, who is an internally displaced person, who is a stateless person, and who is an asylum seeker. I think this is something very important during the deliberations. These clarities will emerge for us. Somebody who crosses the international border alone will be qualified as, a refugee in a sense of the international law, 1951 convention. That is something very important for some of us who are students wanting to learn and understand. I think this is something very important. And we all know the 5 reasons as mentioned in the convention on the refugees, which has been a 1951 convention reference on somebody who is affected, discriminated by race, political opinion, by their social standing, and so on and so forth. We have actually, but today we also have a context of ethnicity, we have context of climate induced displacement, and so many other things are emerging today. We have, besides the geopolitical challenges, political instability, underdevelopment, unequal distribution of resources, effects of climate and environment are all emerging as a compounded challenge. Today, we have almost 26 million plus refugees out of this 82 million forced migrants at the global level. What is notable is almost more than 84-85% are from low and middle income countries who are the host countries. I think that is something very important to take note of, in a way that how the countries which are of low and middle income countries are the major host, what we can call as developing countries, how the internal challenges are being addressed. And, as highlighted, our purpose of this webinar is to have an understanding of refugees, their various facets of challenges, how, the government, the state has been responding to various refugee categories, how the civil society has been responding and taking care of various refugee groups, are something very important. We know that as of now that India hosts almost 4 lakh plus refugees in India. We have 1 lakh plus from Tibet. We have almost another 1 lakh from the Sri Lankan Tamils. We have 36,000 Buddhist ethnic Chakmas and Hajongs from the present-day Bangladesh. We have in the history, in the past, Zoroastrians, Jews who arrived in the medieval period in India. So we have huge tradition. Besides all that, we have the Chittagong Hill Tract people, the Rohingya, Somalia, Sudanese in the recent times. And as a federal country, India, we have the refugees are under the mandate of the union government, MHA, Ministry of Home Affairs, Ministry of External Affairs to govern it. But practically that it is some state which is hosting. We saw that in the recent times when the Myanmar crisis unfolded, how when the refugees, some of them crossed over to India, the government of India, in fact, gave a notification that we will not accept any refugees coming in. But the interesting moment is that we saw, the Manipur state or the Mizoram were able to proactively host the refugees by saying that if they are facing a crisis in the neighborhood and coming over, that it is a duty to take care of them, to protect them. I think that is something very, very interesting and pragmatic way beyond the legal realm. We see the practical thing. We saw similar lines how the Sri Lankan refugees were hosted by, the state of Tamil Nadu, in the past. So this kind of, compassion and empathy becomes an important element besides legal political regimes. And we need to look at those practical aspects of how the host countries can take care of them. In all these contexts, that if we are not signatory, the signatory and non-signatory countries is a binary at the global level. Now the New York Declaration and the Global Compact on Refugees today becomes a framework where all the 193 countries, have been part of the deliberations, including India, in developing this, pertinent framework called the Global Compact on Refugees. And this actually, lays emphasis on, whether you are signatory or non-signatory, that how do we do the responsibility sharing or a burden sharing of refugees in a very effective manner, in an equitable manner, in a very inclusive manner. So that is where, this becomes an important framework for us. So the New York Declaration set in motion two separate and complementary documents, one for the migrants in general and one global compact for refugees, which we are going to deliberate today. It is an important intergovernmental process of negotiation, as highlighted by other speakers today. The Global Compact highlights 4 broad objectives. How to ease pressure on the host countries. As we said, most of the host countries are from low-income developing countries or underdeveloped countries. So that is something important. We need to see how that pressure we are going to ease. Then to enhance the refugee self-reliance, that always one sees the refugees as a burden, quote unquote, but it is something to be seen that how they can also be seen as contributors if they are made self-reliant. And then the third is to expand access to third country solutions, where part of the durable solutions, that how they could be taken to a third country, as a kind of a resettlement. And of course, support conditions in the country of origin for safe and return with dignity, what we used to call it as the voluntary repatriation. So I think these forms the 4 important bedrock points for the global compact on refugees. We need to see how this is actually impacting our legal process, impacting our policies, impacting our practices, more importantly. That is where we have come into this national webinar. Today's deliberations are going to be. So is it like global compact on refugees? Is it a kind of old wine in a new bottle? Does it have any new meaning in terms of its text? Context is something which we need to look into it. We will definitely juxtapose that with the notions of protection, inclusion, care, and see how the World Refugee Day theme could be genuinely upheld in terms of healing, learning shining with the participation of refugees themselves. And of course, we have the associated issues of asylum seekers and stateless population also will be deliberated in today's discussion. I request now our organizing team to paste the, to give the revised program schedule link for all who are here to, follow it up. And with this brief note, I would like to now propose a brief vote of thanks where, at the outset, I would like to record our heartfelt thanks to the UNHCR India, New Delhi office, and the field office at Chennai, and the Vellore Institute of Technology, Andhra Pradesh School of Law, for this very partnership, the idea, which was all worked out in a matter of a week only, in a week time, where we could come together and immediately contact all the concerned resource persons. So I thank the speakers today. In fact, Professor Aravind Tiwari, the Dean, School of Law, Rights and Constitutional Governance, for coming in and providing us the presidential address. I, on behalf of the organizing team, thank Ms. Yugiko for providing us the inaugural address. And I thank Dr. Banerjee for providing the welcome address. I thank Professor Samit Das for providing us the keynote address today, which was very profound and meaningful in terms of drawing the analogy between the refugee crisis and the pandemics, and how the marginality and vulnerability are some of the core issues. I'm sure in today's deliberations, these are going to be the framework in which we will take it ahead. I thank in advance all the resource persons, the invited speakers for today's session, the chair for today's session, and all the speakers who have agreed to come in from academia, from civil society organizations. I will not be naming them now. There's a big long list, but I thank all of them for coming forward in a very the invitation within a very short notice, in the endeavor of expressing our solidarity and our commitment to work towards the refugee protection and resolving statelessness crisis, addressing the asylum seekers issue, and how we could actually moot this very pertinent discussion today towards some kind of a legal framework in India, some kind of a legislation at the minimum, at the maximum to go and participate and implement the global compact on refugees, and in fact the refugee convention signing in a way so that we are able to do this in a legal sense of participating, how we could explore that kind of a possibility, what are the nuances, what are the challenges, and yet how this could be addressed is what we are going to do today. So I thank all the speakers today also who are committed to come in, and we know that we have exceeded the list of the capacity of 100, and there are many who are in waiting and unable to join. We request all of you to communicate, those who are able to join on the YouTube. Our apologies for this limitation that we could not have more than 100. Now I think the program schedule is also pasted in the chat box. Some of you could have a look at it. And with this, we will conclude the inaugural session. Now, shall we start the the first technical session? I would like to invite now Dr. Banerjee to take over as the chair of the next session. And we will have the first technical session will cover the global compact on refugees, covering the legal and political perspectives. That is the technical session, and Dr. Banerjee will chair it. We have eminent speakers, Professor V. Suryanarayanan, who is the founder and former director, Center for South and Southeast Asian Studies, University of Madras. And he had been also the member of the National Security Advisory Board. He will provide us the South Asian geopolitics and the refugee protection from national security perspectives. And the second speaker will be Dr. Srinivas Burra, who is the assistant professor at the Faculty of Legal Studies, South Asian University, New Delhi. He will provide us the Global Compact on Refugees and International Legal Perspectives. We will have Professor Bernard Swamy, who is Director of Loyola Institute of Social Science Training Research at Chennai. He will provide us the Global Compact on Refugees and Migration cum Refugee Policy Impact. These are three eminent speakers who will be there. And over to you, Dr. Banerjee, to take ahead the next session with the introduction of detailed introduction of each speakers. Over to you, Dr. Banerjee. I think we are just a dot on time. 11:30 we are supposed to start, and 11:29 we are handing over to you. Kindly take ahead. Let us ensure that we all keep the time, and manage the time. We have a very packed program. I kindly request all the chairs of technical sessions to take care of the time management and ensure that we do. I'm sure the speakers also will understand. Over to you, Dr. Banerjee. Thank you.
Thank you so much, Dr. Parivelan. And indeed, it's a great privilege to chair this session. And before going to chair this session, I would like to just call upon our speakers of this first morning technical session. Professor Surya Narayana, sir. Sir, if you can, if possible, can you unmute your video? I would request our IT people as well as Ravindran kindly facilitate Professor Narayanan sir, Surya Narayanan sir's video. And I take this opportunity to invite Dr. Srinivas Burra. Dr. Srinivas, yeah, thank you. Yeah, thank you so much. Professor Surya Narayanan sir is also with us right now. I would request Professor Surya Narayanan sir, IT team, kindly just facilitate to unmute the video and audio as well. Ravindran, kindly just check the check Professor Surya Narayanan sir.
Yes, sir, I'm doing it.
Yeah, thank you, thank you. So also Dr. Bernard Swamy. Yeah, thank you, sir. Thank you very much. Yeah, my technical team kindly unmute Dr. Bernard Swamy audio as well. Kindly facilitate. Yeah, that's great. Thank you. Now we need to locate Dr. Surya Narayanan sir. I think morning we have experienced a little trouble due to some technical glitches. We could not able to see Professor Tiwari and Professor Samir Das and Yukiko, Senior Protection Officer of UNHCR. Can I ask a technical team kindly locate Professor Surya Narayanan sir? Yeah, meanwhile, what I will see before our technical team locate and unmute, facilitate Professor Surya Narayanan sir, this particular session is primarily focused on global compact on refugees, legal and political perspectives, because we have experts from the field as well as experts from the academia and also three important speakers. And as Dr. Parivelan has suggested, I would request three of you please kindly maintain the time, maybe 20 minutes each. That becomes maybe an hour. After that, 1.5 hours, half an hour or so, we can have a discussion from the participants. I would request all the participants kindly leave your questions in the question and answers, which you have the option of sending the question and answers. And we have a team of coordinators and from the organizing committee. They will present your questions to the three speakers. While you are writing your questions, I would request you to mention the speaker's name to whom you are directing the question. Okay. So now I would like to introduce, I take this opportunity to thank and introduce all the three speakers. First, Professor Surya Narayanan sir. He is one of the India's leading expert on refugees And for more than 30 years, he has been researching, writing extensively on Sri Lankan refugees and advocating for the national refugee framework that balances both the humanitarian concerns of the refugees and national security interest of the India. And he served as a former director of the Center for South and Southeastern Studies, University of Madras, Chennai, in India. He also served as the member of the National Security Advisor from the year 2008 to 2010. Now, Dr. Burra Srinivas is an expert of international law and particularly refugee law and humanitarian law. He is currently working as a senior assistant professor of Faculty of Legal Studies. He has completed his doctorate from the Jawaharlal Nehru University Center for International Legal Studies. He joined in the Asian and Asian and African Legal Consultative Organization, and where that's intergovernmental organization, where that organization has specifically focused on refugee issues and refugee problems relating to African and Asian continent. He has contributed immensely on that as well. And subsequently joined an international committee of the Red Cross. There also, while working on the international humanitarian law, he focused on the concerns of refugees as well. He is one of the regular contributors to the European Journal of International Law, etc. And he writes extensively on these areas. And his areas of expertise are humanitarian law, refugee law, law of treaties, international terrorism, transnational organized crime, and international works of International Law Commission. And now we have Professor Surya Narayanan, sir. I welcome him. Sir, thank you so much for taking your time and joining with us. And may I request Professor Surya Narayanan, sir, unmute your audio also. We could see you. Thank you so much. And before inviting Surya Narayanan, sir, I would like to introduce Dr. Bernard Swamy. Bernard Swamy is currently the Dean of the School of Excellence, Loyola Chennai, and also serving as a director, Loyola Institute of Social Sciences, Training and Research. He has done an extensive work in the areas of refugees. He went to San Remo in Italy in the year 2016, selected by UNHCR for a pilot course on statelessness and the International Institute of International Humanitarian Law, and he was invited for a global academic network meeting in Geneva in 2018, and is the member of Global Compact on Refugees. So these are the very impressive speakers we have. With this, I will now request Professor Surya Narayanan, sir, to interact with our gathering. Thank you so much, sir.
Can you kindly indicate the time, please, for each speaker?
Yeah, each speaker, we are maximum of 20 minutes each. That means it's a 1 hour. Speakers will speak. After that, we have half an hour for the discussions. And I would request all the participants leave your questions in the chat box or Q&A. Our organizers will pose the questions to the speakers. Thank you. Sir, Narayan, sir.
Chairman Dr. Banerjee, fellow panelists, other distinguished guests, and my student friends. Can you hear me? Can you see me?
Yes, sir. We can see you and hear you. Yes.
Thank you, sir.
May I at the outset express my heartfelt thanks to Dr. Parivelan and other organizations who are organizing this webinar this morning. In this invitation letter, Dr. Parivelan mentioned and Dr. Banerjee reiterated that I can take about 20 minutes to make my point of view clear. There lies the problem. It takes about 15 minutes for a professor to warm up in the classroom and to expect him to close his presentation in 20 minutes is an arduous task. However, I shall try to be as brief as possible. The Hollywood actress Elizabeth Taylor told her husband after her 9th marriage, "This too shall be brief." I've been asked to speak on the South Asian geopolitics and how it affects the refugee phenomenon. Before that, I would like to make one or two points. I do not know how many of the students have heard of Professor Valentine Daniel. Professor Valentine Daniel is a professor for cultural anthropology in Columbia University, and he has done pioneering work on refugees in general and Sri Lankan refugees in particular. In his book, Mistrusting Refugees, he gives a new definition of refugees. We all know about the UNHCR definition of a refugee. Now, Professor Valentine Daniel mentions that the refugee is a person who has lost trust in the society in which he lives, lost trust in the government under which he is governed, and therefore it's only a question of time before he crosses the border. A person who mentally has mistrusting the society in which he lives has already become a refugee. This is a definition which I want all of you to wonder upon, not merely the UNHCR definition. Now, if you look at the geopolitics of South Asia, have the map of South Asia before, have the map of Asia before you, the first thing that strikes you is the dominance of India over the region. India has borders with all the other countries in South Asia, but none of these countries have borders with each other. Population of India is more than the population of all other South Asian countries. Our army, our air force, our navy is more than all the other navies, air force and armies put together. Our economic resources are more than all the other countries put together. So there is naturally a suspicion about India's intentions and misgivings. And some of the actions that we did rightly perhaps, like dismembering Pakistan and creating Bangladesh, annexation of Sikkim into Indian territory, all these things have created misgivings among our neighboring countries that India wants to dominate the region. So they approach India in a different way. They gang up against India to cut India to size. South Asia as a nuclear-free zone and other concepts which have been made by the South Asian countries at different levels. Now, how do we remove these fears and misgivings and create a situation where we all live together harmoniously, in amity, in peace, in goodwill? That is the challenge that is facing us today. I must also point out that some of the statements made by our diplomats have also added to the apprehension. During the days after the India-Sri Lanka Accord, Ambassador Jane Dixit was our High Commissioner, and she used to be popularly referred by the local people as the Viceroy of India. That is, she was the one who rules that country. So this fear and misgiving has to be removed, and we must create a situation where we all South Asian countries work together. I'm fond of narrating a story which I use for making South Asia an area of cooperation and peace. The story of a missionary school which was started in the Adivasi area of Madhya Pradesh by the Christian missionaries. Lot of students joined the school. They wanted to celebrate the first anniversary of the school, and they decided to hold a sports meet, 100 meters dash. All the boys were asked to assemble. On your mark, get set and go. All the boys ran. There was a strong boy who was running far ahead of others, and everybody was cheering him. But midway he stopped. The principal, who was a nun, asked him, "You're running so fast, you would have easily lifted the trophy. But midway you stopped. Why did you stop?" The boy told her, "Madam, in our community, that victory is the greatest victory where we all win together." This concept of winning together, this concept of fighting evils in a joint way should be the basic principle of regional cooperation, according to me. In his invitation letter to me, Dr. Parivel wanted me to speak on what is the National Security Advisory Board doing on the issue of refugee protection and all. I want to give you two points for your consideration. After he retired as the National Security Advisor, M.K. Narayanan spoke in a meeting in Music Academy in Madras a few years ago on the Sri Lankan refugee situation, where he said, perhaps reflecting the then government's point of view, that it's only a question of time before we give Indian citizenship to the refugees. The second one, I was a member of the National Security Advisory Board during 2006-2010, when the fourth Ilam War was going on. When the war started, Sri Lanka adopted a new strategy. They knew the refugees pour into Tamil Nadu, naturally Tamil Nadu will be afraid. So what they did was to consolidate the Sri Lankan side of the Park Bay. So from Mannar to outer islands in Jaffna, the Navy controlled the whole sea coast. So that those who wanted to come as refugees to India cannot reach the sea coast. Otherwise, the refugees will assemble in the Madhu church, where they will contact the fishermen, and the fishermen will arrange them to take to India on the payment of certain amount. And the fishermen will leave them very near the seashore. They will wade through the water and seek asylum in Tamil Nadu. But during the fourth Elam War, the number of refugees who came to India started dwindling down because the Navy was controlling the other side of the Park Bay. And our Coast Guard was also patrolling our side of the Park Bay, so the refugees do not pour into that. When the war against the Tigers became a war against the Tamil civilians, and the Sri Lankan Air Force and armed forces began to destroy orphanages, churches, temples, etc., and large number of civilian population were affected, I wanted to make a presentation on Sri Lanka in the National Security Advisory Board. And the Joint Secretary in the Ministry of External Affairs, Tirumurthy, was also present. And the convener of the National Security Advisory Board was Ambassador Shankar Bajpai. I made a forceful plea that we must pressurize, persuade the Sri Lankan government to declare a ceasefire, so that those innocent civilians who are caught between the Sinhalese land and the Tamil Tigers could be saved. That is, those who wanted to escape the war zone and being subjected to savage bombardment by the Sri Lankan armed forces have an opportunity to leave the war zone and come elsewhere. And then the war can be resumed. I will not want the war against the tigers to be stopped, but my intention was only to see to it that the innocent civilians were not affected. I also pointed out that one of the major principles of international law was the responsibility to protect R2P, which was accepted by the United Nations unanimously on the 50th anniversary of the General Assembly. Unfortunately, my point of view was not supported by majority of the members. Only 7 of the members supported me. The rest 20 of them were with the government, who did not want a ceasefire to be declared. The result was that, according to the United Nations, 40,000 innocent civilians were killed during the last stage of the Fourth Yemen War. Our hands are also tainted with blood, and all the perfumes of Arabia, as Lady Macbeth mentions, the sleepwalking scenes, cannot remove the stain of the blood in our hands. So I miserably failed in that, and the end result was 40, according to the United Nations, maybe more, 40,000 innocent civilians were killed in the savage war. Now, let us take the case of, I've been pleading, though we are not a signatory to the UNHCR Convention on the Optional Protocol, that we should, as early as possible, have a national security law, a national refugee law, which defines who is a refugee, because we do not have a definition of the refugee, the problem of which I will discuss later, which incorporates the principles of non-refoulement. That is, the refugee cannot be sent back against his wishes, and then his rights, and what is more, the security concerns of the state. The Rajiv Gandhi assassination case, among the 27 accused, 7 of them were registered as refugees. So there is a security concern, legitimate security concern that we have. So incorporating the security concern and the humanitarian concern, we should enact a national refugee law. Now, in the absence of a national refugee law, various state governments are acting in its own way. Now, Tamil Nadu government, fortunately, from 1983, are permitting the refugees to work outside the camps. But the Chakma refugees are not permitted to work. Now, we provided free education to them, but Jayalalitha, after Rajiv Gandhi's assassination, stopped it. She also wanted the refugees to be forcibly sent back to Sri Lanka. The Human Rights Organization filed a case in the Madras High Court stating that India is violating the principle of non-refoulement. Narasimha Rao, the Prime Minister, and more than Narasimha Rao, Muchkund Dubey, the Foreign Secretary, allowed the limited presence of the UNHCR to certify the voluntariness of repatriation. And that is a statesmanly step, as a result of which today no refugee can be forcibly sent back to Sri Lanka. So we should speedily have a national refugee law, about which the national refugee law is there. Now, on the refugee policy, I want to mention 2 or 3 things. During the Nehru era, referring specifically to the Tibetan refugees, Nehru in 1959, in a statement in Lok Sabha, explained the 3 pillars of refugee policy. 1, that it is a bilateral issue. It's an issue between China and India. 2, the refugees will be treated with compassion and understanding. And 3rd, when normalcy returns, the refugees should go back. When normalcy returns, the refugees should go back. The present government, Narendra Modi government, had decided to amend the national refugee law, perhaps in the right spirit, because the BJP had always been for giving citizenship to those Hindus who are being persecuted in the Islamic states of Afghanistan, Pakistan, and Bangladesh. As a result of this, they enacted the 2019 amendment to the Citizenship Act, by which the non-Muslims from these countries can come to India and can get Indian citizenship. Unfortunately, they have omitted Sri Lanka from the list. And Amit Shah, while piloting the bill in the parliament, said these three countries are theocracies, whereas Sri Lanka is not a theocracy. Sri Lanka, strictly speaking, is not a theocracy, but I would like to point out the constitution mentions that it is the duty of the state to promote and foster Buddhist religion. In actual purposes, it is virtually a theocracy. According to the Hindu groups in Sri Lanka, since the dawn of independence, about 200 temples have been desecrated by the Sinhalese groups. They have committed rape, they have committed arson, they have committed various crimes against the people of Indian origin as well as the Sri Lankan Tamils. Does Amit Shah want to say that loot committed by a Sinhalese is not a loot? Is rape committed by a Sinhalese is not a loot? And therefore, we in Tamil Nadu are trying to mobilize the people to passionately make a plea to the central government that Sri Lanka should also be included in that. There are two important points which are denying the Sri Lankan Tamil refugees in Tamil Nadu, about 100,000 in number, both camp and non-camp, from getting citizenship. The first point is that in 1983, the central government issued a circular to Tamil Nadu government saying that the refugees are not entitled for citizenship. In the context of the Citizenship Amendment Act, we appeal to the central government that this circular should be withdrawn. The second one, 2 years ago, answering to a starred question in Rajya Sabha, the Home Minister said about the legal status of the Sri Lankan refugees that they are illegal immigrants. And as illegal immigrants, they have no right for citizenship. Now, the refugees who have come from Afghanistan, Pakistan, and Bangladesh are not treated as legal immigrants. They are treated as asylum seekers, and they can apply for citizenship provided they fulfill certain conditions. Now, the Sri Lankan Tamil refugees, all of them, they are entitled for citizenship of India by naturalization. As far as the Sri Lankan Tamils are concerned, they are citizens of Sri Lanka and they want Indian citizenship. They must renounce Sri Lankan citizenship. And in my frequent conversation with them, they agreed that they want Indian citizenship and they're willing to surrender their Sri Lankan citizenship. As far as the Indian origin Tamils are concerned, the Tamil refugees will number about 29,500. Many of them are stateless. And the Sri Lankan government has enacted a law in 2003 by which all stateless people could get Sri Lankan citizenship. This desire to take Indian citizenship is widely prevalent among the refugees who are born in India after 1983. They say we don't want to go back. We got assimilated here, we have studied here, we are qualified here and all. Without citizenship, most of these people are working for lesser pay on a job for which they don't require the present qualification. Now, many of the refugees are working as painters in construction work. Some of them are engineers because they have to be citizens to get a job commensurate to engineering qualification. They get 800 rupees as salary. But this 800 rupees is more than what they will get in Sri Lanka. They enjoy a standard of living which is higher than what the Indian Tamils in Sri Lanka. And the only thing is that they can get citizenship if they go back. And most of them desire that India should confer citizenship on them. I shall stop here. I think having more time or
we have yeah, sir. We have 2 more minutes. 2 to 3 minutes you can.
2 more minutes I'll give to the next speaker. You can give
okay,
2 more,
yeah,
2 more minutes. You can give to Dr. Bernard Swamy. If there are any questions or queries, I'm willing to answer. difficult question, Dr. Banerjee will answer. Simpler one by answer.
Thank you very much, sir. I think, sir, would you like to take questions now, or would you wait
I think it
until
will be
then
better if the
for the
questions are
speakers,
asked.
sir?
Questions are given to me now. Can you do it? Or should I wait till the end?
Yes, sir. Yes, sir.
Collectively in the
No,
question.
sir. Yes, Pari. Pari?
Yeah, I'm just saying that we said that we will have all the speakers' speech completed, then we will have the question and answer session in the end.
Okay. So I request.
I submit to Parivalan's orders.
Thank you, sir. Actually, that's what we told the participants. So participants will, I think, post their questions. We can request them also to do so from chair side. Yeah.
Yeah. Okay, sir. Yeah. Thank you. Thank you very much, sir. Thank you, Surnarayanan, sir. And it's wonderful to know from your experiences and your contribution about the problems of Tamil refugees in Sri Lanka and as well as India. And with this note, now I would like to request Dr. Burra Srinivas. Thank you, Dr. Srinivas.
Okay. Thank you, Professor Banerjee. Can you hear me? Am I audible?
Yes, yes, yes.
Okay,
Srinivas.
okay. Okay, thank you, Professor Banerjee, and I also thank Professor Parivalan and the UNHCR for giving me this opportunity to be part of this Refugee Day celebrations, a kind of a celebration it is, but of course it can be looked at in different ways, but at least reflecting on issues relating to refugees and refugee protection. So the topic that is given to me is Global Compact on Refugees and Legal Perspectives. Yes, this is an important relation which one needs to reflect on as to how the Global Compact on Refugees has any, whether it has any implications on the question of legal aspects in relation to protection of refugees. But most importantly, one is to look at it at a global level, how the Global Compact on Refugees could have implications to the existing legal framework. But I would like to focus more specifically on Indian context as to how this relationship can be looked at. So therefore, I would like to make my presentation broadly in three parts. The first one is to look at how the Global Compact on Refugees can be related to the Indian context. Means what could be its relevance, because keeping in view the peculiar nature of India and India not being a party to the Refugee Convention. That is one aspect. The second aspect is that to get into the question of that, in the absence of any not becoming a party to the Refugee Convention and the protocol, what other legal obligations can be explored so far as India is concerned? Legal obligations in the sense of international law, because that is where somewhere I think government of India, the Indian state's position keeps coming back to say that India is not a party to the Refugee Convention. There are no international law obligations. So to critically evaluate that view of taken by government of India and at various other fora and see whether there are any other legal obligations that India can think of or we can think of vis-a-vis India. Now that can be divided into two aspects. One is to that is where I try to a little more legal aspect, that is that what are the India's obligations outside the convention framework, and to look at it customary international obligations, which is known for many law students would be able to relate it. That is one aspect of it. The other aspect that I would like to reflect on is that recent work at the international level on other aspects, particularly by the International Law Commission, on the question of norms of jus cogens as part of international law, but relating that aspect to the principle of non-refoulement and what the International Law Commission has said and what kind of implications that would have to India. So therefore, these three aspects we would like to look at it. The first is the question of GCR and India relationship. The second is that India's obligations beyond the convention framework, particularly looking at customary international law framework, as well as going as a third component the norms of risk against where India probably would be bound by its obligations under international law. Starting with the first aspect of it, that India's relationship or what kind of implications Global Compact on Refugees would have. Now, if you look at the document, the Global Compact on Refugees, it is one of the comprehensive documents probably on refugees issues that have come out at the multilateral level, at the global level. So therefore, in that sense, the Global Compact on Refugees can be considered as an important development. And another important aspect of it is that it has got an overwhelming support from various countries, including countries like India, which are not parties to the Refugee Convention. So there is an overwhelming support across the world from states, interestingly, while they voted in the United Nations General Assembly. So that is one important which needs to be kept in mind. But there is a contradiction also. There is an overwhelming support for the Global Compact on Refugees, but at the same time, the period through which the Global Compact on Refugees was being negotiated at the global level, there was a huge backlash on refugees on the ground, in the sense that there is a large number of pushback was happening at different parts of the world, including Mediterranean, Syrian refugees. Of course, in the South Asian context, we have that in the form of Rohingya refugees. So there is a contradiction between what states are saying at the global level, at a formal fora or at a diplomatic fora, and there is a contradiction with the practice, what states are following. I'm not saying that all the states, I'm not talking about all the states, but good number of states were practicing kind of non-entry to refugees, means not allowing the asylum seekers into their territory. So why this contradiction between at the global level in terms of adopting the Global Compact on Refugees, but at the ground level, there is a refusal to accept asylum seekers. Now, that forces us, compels us to look at what really GCR does. Now, it probably one reason why states are okay to accept Global Compact on Refugees, including states like India, is that it is not a legally binding document. So there is no legal obligation for states to comply with GCR framework. So that could be one reason why states consider it as more as a kind of a suggestive documents at the global level without any legal implications. When we say legal implications, it is important that there won't be any legal obligations and there won't be any consequences for the failure to comply with those obligations which are part of Global Compact on Refugees. Now, that could be one reason which can be understood as what made states to overwhelmingly accept, including those states.
To share the thing with Nandakishore, Professor Dr. Nandakishore.
Dr. Pari, can you just mute your audio, please?
Yes. Okay. So that could be one reason why. That could be one reason why those states, even those states which are not parties to the refugee conventions, were in favor of voting in favor of Global Compact on Refugees. That could be one explanation that one can. The second important component about the Global Compact on Refugees, where probably states would have seen it as a positive aspect, is that the approach in terms of the multi-stakeholder approach, in the sense that the Global Compact on Refugees also talks about involving different stakeholders as part of the refugee protection. Now, here it is an important thing. I think it is a positive development to welcome the involvement of different stakeholders as part of the process of refugee protection. But I think that would probably is being seen by states as a positive thing. Somewhere, I think that under international legal framework, the primary obligation lies with the state. But when it comes to Global Compact on Refugees, in fact, in other words, of course, it's not diluting the obligations of the states, but it is also focusing on other stakeholders who could be involved in the protection of refugees. Probably, I think from the state's point of view, they consider it, even those states which are not parties to the Refugee Convention, would consider it as a positive development. In other words, it is not imposing any hardcore obligations on states themselves, which normally the law does. So therefore, I think probably these are the reasons why in there is an overwhelming support to the Global Compact on Refugees. Now, the next point that comes that needs to be reflected on is that what is its impact on states like India, which are not parties to the Refugee Convention? If you look at carefully the Global Compact on Refugees, it does not have or anything or not does not have much of impact on those states which are not parties to the Refugee Convention. Though it does not specifically say so, but the structure seems to predominantly in terms of reinforcing obligations in respect of those states which are parties to the Refugee Convention. There is no specific framework particularly addressing those states which are not parties to the Refugee Convention. Therefore, it looks like for those states like India, which is not a party to the Refugee Convention, the impact of Global Compact on refugees does not seem to be significant. In fact, this is what is said by the delegate of India. When the negotiation was happening in the UN General Assembly, the statement made by India was very clear that there has to be a difference between the obligations in relation to states which are parties to the convention and in relation to states which are not parties to the Refugee Convention. So therefore, Government of India wants to make a very clear distinction between those states which are parties to the convention and which are not parties to the convention. So in that sense, I think that the significance of GCR to the context like India is minimal, in the sense that it is not significantly adding to the absence of the legal position, because that is where we are very much worried about India's position in the recent past. So therefore, I think the relation between GCR and countries like India, which are not parties to the Refugee Convention, seems to be not that significant in terms of putting new obligations or accepting new obligations by these states. Now, that is where we have to look at the relationship between India and GCR. Again, coming further specifically to India's position in relation to its legal obligations, it is not a part, it's a very peculiar kind of a situation. It's not a party to the Refugee Convention. It is part of the executive committee, which is of course an important body. It does not have a national legislation. It does not have a national legislation to deal with refugee situation, but institutions like UNHCR continue to operate from the territory of India. So the relation is the situation in terms of a law is a little more complex situation so far as India is concerned. And its practice, of course, everybody accepts that India has a long practice of hosting refugees, asylum seekers for a longer period of time in large numbers. Now that is a history. The recent past seems to be not the same because of various examples that we can cite, whether it is Rohingyas, of the refugees, or in the recent past with regard to the military coup in Myanmar and later the movement of people, how that was dealt with. Now, these are some of the examples which show us that the practice that was historically followed by India without even becoming a party to international obligations seems to be fundamentally changing in many ways at the policy level. It's not at the legal level because law has not changed much. But of course, law also is changing in a way, as Professor Suryanarayan has pointed out about the Citizenship Amendment Act. It is not a question of refugees, but it does have indirect implications to the question of the refugee status and asylum seekers in the Indian context, if you look at from international law point of view. So therefore, there were examples when the practice of India was to invite refugees, host them, despite not having legal obligations. Many critical international lawyers, including professors like B.S. Chimney, who were critical of the refugee regime at the global level, argued that India doesn't need to become a party to the Refugee Convention because its practice has been perfectly well. Probably there is a need for national legislation rather than becoming a party to the Refugee Convention. Now, this was the position taken by Professor Chimney in early 2000s. So that was the time he took this position. But significantly and very interestingly, since the practice of India has been changing over a period of time, particularly in the last couple of years, 6 to 7 or 10 years, even people like Professor Chimney has changed its opinion. Now he argues, at least if he does not argue, he says that India should consider becoming a party to the Refugee Convention. The reason why this shift is happening is that also explains us in terms of the difference between policy and the law. I'm not saying that everything is good with law. I'm not trying to argue that way, but I'm only trying to put across the difference between policy and law. When certain things remain at the policy level, the challenge would be that it will be subjected to the political priorities of the government of the day. Had there been a legal obligation, it would have been a little more difficult. And the process of making law also involves the executive, legislature, and also there would be implications in terms of the judiciary coming into picture. But if the matter remains at the policy level, it primarily remains at the level of executive. Now, the executive is essentially impacted by the government of the day. Now, that is what seems to be happening in relation to the refugee situation currently in India, in the absence of the national legislation on or international law obligations. Therefore, I think that is the reason why people like Professor Chimney are arguing that somewhere you need to have some legal obligations for states like India to have certain implications at the global level as well as at the domestic level. Now, I'll leave that part of legal aspect at the domestic level of India and get into the international law aspect of, since India is not a party to the Refugee Convention, whether there are any other obligations that India can think of. The two aspects that I am trying to look at it is customary international obligations and the norms of use coherence. When we look at customary international law, so when we refer to international law, we mostly refer to the treaties. But the equally important source of international law is a customary international law. So therefore, when we refer to India is not a party to the Refugee Convention, that is only one source of international law, because there are also other sources of international law which we need to reflect on. That is where the custom as a source of international law becomes extremely important. So therefore, if India is not a party to, and India continuously argues that it does not have international law obligations because it is not a party to the Refugee Convention, that needs to be looked at carefully. That statement is not completely true, because India does have its obligations under customary international law. In what form those obligations are can be looked at. Now, the obligation is particularly looking at the principle of non-refoulement. All the students of refugee law would know that principle of non-refoulement is the principle that the essence is that the asylum seeker should not be sent back to a territory or a place where there is a fear of persecution to those individuals. Now, this is an important principle of refugee law, but it also has become part of human rights treaties. Like Torture Convention has this provision, and also the Enforced Disappearance Convention has this provision. And unfortunately, India is not a party to any of these treaties. It's not a party to the Refugee Convention, not a party to the Refugee Treaty, Torture Convention, not a party to the Enforced Disappearance Convention. However, the principle of non-refoulement in relation to the refugee law framework is arguably has attained the status of customary international law. So it is not my view that I am trying to argue. It has been repeatedly said. It has been repeatedly said by the executive committee. In some of its conclusions, the executive committee of the UNHCR, in fact, repeatedly said that the principle of non-refoulement has become part of customary international law. And very interestingly, these conclusions have been adopted by the EXCOM after India became a part of the EXCOM. So it is not that something that EXCOM said prior to India becoming part of the EXCOM. In fact, this has been repeatedly said at several places, in several conclusions by the EXCOM after India became part of the EXCOM. So therefore, one can very well say that India consented to this position adopted by the EXCOM. In fact, even the UNHCR itself has very clearly said that principle of non-refoulement has become a part of customary international. And very interestingly, when UNHCR said this in its document, it relied on India's practice. Now, if you look at what constitutes customary international law, it constitutes two components. One is a state practice and opinio juris. So UNHCR, while arguing that in one of its documents that principle of non-refoulement has become part of customary international law, interestingly, it has relied upon the practice by countries like India, which are not parties to the Refugee Convention, but which have hosted large number of refugees. So it is taken as an important state practice for the purpose of establishing the principle of non-refoulement as part of customary international law. So therefore, India's state practice of hosting large number of refugees, asylum seekers and refugees, without becoming a party to the Refugee Convention, has contributed to the formation of customary international law as one of the sources of international law. Therefore, it becomes binding on India itself as another important component of international law. However, some of the students of international law might ask that, but in the recent past, India's practice has changed. Therefore, how can we say that India's state practice has contributed to the formation of customary international law. And to answer that question, in fact, that question was answered long ago by International Court of Justice. It said that if a state practice changes after the formation of customary international law, that is not the new state practice, but that would be amounted the violation of the existing customary international law. So therefore, India's changed practice now of rejecting asylum seekers would amount to violation of customary international law as it was held by the International Court of Justice. So therefore, that aspect of looking at principle of non-reforma as an obligation on India, as a customary international law principle, cannot be overlooked. And it is more important that, unfortunately, the Indian Supreme Court also has not reflected much on this aspect in the recent jurisprudence. That, I think, probably one needs to, some of the scholars of Indian law, constitutional law, have perfectly pointed out that question as to how Indian judiciary failed to take note of those aspects. The last point, very quickly, I'll mention is that with regard to the nature of principle of jus cogens. Under international law, very quickly, I'd say that what we consider certain principles as principles of or norms of jus cogens is that from which no derogation is permitted. So those principles from which no derogation is permitted. In other words, a state may not be a party to the convention. A particular principle may not be part of customary international law. Of course, that's an important part for norms of jus cogens. But still, the principles of norms of jus cogens are binding on all states. That is a general understanding of international law. For students of international law, we're well aware of that. Now, the question comes in that whether the principle of non-reforma has become part of the principle or attained the status of a norm of jus cogens or not. For that, we need to look at the recent work of the International Law Commission. The recent work of the International Law Commission, which focused on the formation of the norms of jus cogens, looked at the entire framework of jus cogens. I'm not going into the details of what the work of the International Law Commission in terms of what constitutes norms of jus cogens. However, while adopting its preliminary work in the first reading, the International Law Commission has identified 8 aspects of international law as norms of attaining the status of norms of jus cogens. It talks about the torture, self-determination, and a few other issues. However, it has not included the principle of non-reforma. So it has not included in the annex identified principles of norms of jus cogens. But that is not the end of the story. The important aspect of it is when the special rapporteur came up with his report, 4th report, he included the principle of non-reforma as a norm of jus cogens. However, it has not appeared in the final list. But the International Law Commission has very clearly said that those which are this list of 8 components in the annex is not an exhaustive list, means that other aspects can be included. And very specifically, the special rapporteur identified 3 other in addition to those 8. These 3 are the question of the issue of right to life, the enforced disappearance, and the principle of non-reforma. So therefore, at the international level, the principle of non-reforma arguably has attained the status of a norm of jus cogens. And when India made a statement on this subject matter, in fact, it has not countered special rapporteur's position. It has not countered the special rapporteur's position. So therefore, it can be very clearly said that India seems to be, if not in agreement, it has not at least countered the special rapporteur's position that the principle of non-reforma has attained the status of norm of jus cogens from which no derogation is permitted, including countries like India. So therefore, to sum it up, that in the absence of treaty obligations for India, because India is not a party to the convention and the protocol, there is a clear legal position at the international level that India does have international law obligations which need to be respected at the domestic level, particularly in the form of the principle of non-reforma as part of customary international law, and arguably the principle of non-reforma as a norm of jus cogens from which no derogation is permitted. So it is important that wherever we talk about India's legal obligations at the international level, probably I think we should not confine just to the Refugee Convention itself or the protocol. We need to go into other aspects of international law or other sources of international law, which are equally important as the treaties as sources of international law. That is where India's obligations become important. That is where India cannot deny its obligations, particularly with regard to the principle of non-reform. Thank you.
Thank you so much, Srinivas. It is such a lucid and eloquent presentation by you and your opinions with regard to India's stand as well as international law position with regard to the protection of the refugees are concerned. Thank you so much for your wonderful presentation. And now I would like to request Dr. Bernard D. Sami. Sir.
Thank you. At the outset, would like to thank Dr. Pari, his center, even HCR India, and the Brit University for organizing today's webinar seminar to commemorate the International Refugee Day. I hope I am audible, visible, and audible, right?
Yes, sir.
Okay. Okay. What I thought that I will do today is to unpack the GCR, because it is good that we look at the GCR and the nuts and bolts of GCR so that we understand better, better the global compact on refugees. Number one, what I will do is to look at the guiding principles. Maybe the GCR, as pointed out by Dr. Srinivas Gura, is a non-binding one. So this is the reason why most of the state parties were willing to be part of the GCR, because the 1951 convention or the 1967 protocol received this much of support as the GCR received. So in that way, he rightly pointed out that this is non-binding and obligations are very less. And no one is going to question a country, because you have not done this, you are being, action being taken on you. So in that way, I think, the GCR is non-binding, number one. Number two, the principles enshrined in the GCR are the principles of the 1951 Convention, 1967 Protocol, 1954 Stateless Convention, 1961 reduction of the Stateless Convention, and all the human rights treaties. So whether it is on racism or women or children, all of them are included in this, and these are the principles. In other words, if a student is going to look at what are the sources for the GCR, these are the sources for the GCR. So the general principles of the guiding principles of the GCR are coming from this, though not explicitly mentioned as non-reforma and many other things, but definitely the grounding principles are the principles of the two conventions and the Stateless Convention and all the human rights treaties. They are all part of the guiding principles. So this, I thought that I will place it before the audience. And secondly, when you look at the principles, the four principles that are enshrined, and particularly if you look at the ease pressure on host countries, so explicitly the GCR has not mentioned that the reintegration with the country where they have sought asylum is not mentioned explicitly, but more the GCR talks about easing the pressure on host countries. And secondly, it says enhancing the refugee self-reliance. By enhancing the refugee self-reliance, the GCR is, more, it talks about the multi-stakeholders and about which Dr. Gura also mentioned. And looking at the refugees more in terms of, more from the economic perspective rather than from the political and from the, social perspective. So in that way, more than a legal personality as a person, before law, the GCR is looking at the refugee from the point of view of, a refugee has sought asylum. He is in a host country, and the host country, in the host country, he can work and he can, improve his economic condition. More about that, more about, his economic status rather than his his legal his status as a legal person and his community as a legal person and other things. So in that way, one can see a kind of a dilution as far as the objectives are concerned. And thirdly, the multi-stakeholders one, about which Dr. Bora was also telling. In the multi-stakeholders, they brought in many stakeholders in the refugee regime or the countries which are hosting refugees. And you will find a lot of people, local communities are given a lot of importance because it is the local communities which receive the refugees. So in that way, what kind of protection they can come in, what kind of integration that can take place, what kind of other things that can happen happen with the local communities, local authorities and local actors in both urban and rural areas is mentioned very elaborately. And the networks of cities and municipalities, they are all mentioned, and the faith-based communities for the first time has been mentioned, and what role the faith-based communities can do for refugees in the host countries is mentioned, and public-private partnership has been given lot of focus in this GCR. In that way, now it is not the duty of the state alone, but also the private sector, and inviting the private sector to be part of addressing the issue of refugees, and particularly providing them self-reliance is one of the objectives. So for that, the public-private partnership is needed, and the private sector is invited and welcomed in a very big way in the ECR, whether it is for good or for bad. We have to look at that, critically. One aspect about which I would like to highlight here is the global academic network on refugees. So this is something new. Myself and Dr. Burra were there for the consultation, and this is something new where, in the multi-stakeholders consultation, in the multi-stakeholders partnership, the universities, or the education institutions are welcome. Welcome for what? They can start a refugee studies program. We don't have refugee studies program in many universities, except the Western universities in North, in the global North. Some of the universities are having very big institutions are having departments and centers, but definitely not in the South. But it is an indication that you can start refugee studies program and courses. And more than that, the refugee students should be part of the higher educational initiatives. And one of the data that is given by information given by the UNHCR is this: not even 1% of the refugees are in the higher education institutions.
So, sir, sorry to interrupt. It looks like there is some audio problem which is happening. Can the technical team rectify it, please? There is some echo sound. Yeah. Professor, please continue. Sorry for the interruption.
Okay. So there is, according to the UNHCR, there is only 1% of the refugees who are in the higher education institutions. Then you can imagine that if you are a refugee, then one cannot enter the portals of higher education, and that is the status. So in terms of scholarship, in terms of in terms of courses, in terms of admission to universities and other higher education institutions, this is one thing that is it's a welcome feature that has been mentioned in the GCR, namely a global academic network on refugees, which will facilitate courses and research on refugees at one level, and second level offering scholarships and offering admissions to the refugee students, because the number is less than 1%, and they have every right to enter the portals of higher education. And this is being done, and that is something good about the GCR. And if you look at the meeting needs and supporting the communities, this is the fourth part, or in other words, meeting needs and supporting communities is the second part of the GCR. If you go through it carefully, one can, see, naturally one would go through this and then compare it with the 1951 convention. And the 1951 convention has already given all the rights, to the refugees, right to education, religion. Religion is not explicitly mentioned here. in the GCR and the jobs and livelihoods, and this is mentioned once again in 1951 convention, and movable and immovable property 1951 convention. So there is not, it is not explicitly mentioned in the in the GCR, but women and girls and youth and children, because half of the population are youth and half of the population are women. So accommodation, energy, natural resources. I think when you compare the 1951 convention and the rights that are guaranteed in the name of the right, and here meeting the needs and supporting the communities, I think the standards are compromised, and less is said about the refugee and the rights in terms of rights, and more in terms of facilities and concessions and opportunities and other things which are expected from the host communities is mentioned, and that is also has to be taken note of. And when you come to the solutions that are given in the DCR, the first solution, as all of us know, is the durable solution, that support for countries of origin and voluntary repatriation. There is a lot of focus on support to countries of origin and voluntary repatriation. Anyway, one of the best durable solutions is voluntary repatriation, and that has been mentioned. And we have no problem with that. But the GCR also says that we will go to the root cause. When they talk about going to the root cause of addressing the refugee issue, the third country involvement is not mentioned, or third country involvement is absolutely given a go. So in that way, what about the countries which are responsible for creating the refugee situation, or creating a condition in which the refugees are produced or manufactured and leaving the country? So in that way, that is absent. And second thing, the countries are also closing the doors. The whole global north is closing the doors. The countries which are closing the doors. Right to asylum is a basic fundamental right that we found in UDHR. And right to asylum is not mentioned except, as a footnote in one place, Dr. Chimney says that right to asylum is not mentioned. So right to asylum, right to nationality, these are all compromised. And more they say that they are going, the GCR is saying that we will go to the root cause of, the countries that produce the refugees. But definitely the third country involvement is not mentioned, and that is a sad aspect as far as the GCR is concerned. Anyway, the resettlement is there. Countries can, the Canadian model is mentioned, where the individuals also can sponsor the refugees and invite them to the countries and give them asylum. That is mentioned as a good practice. But we don't know how many of the countries will be willing to receive the refugees is another aspect that needs our attention. And the solutions is very broadly dealt with, and one can have a look at it and then look at it critically also. Finally, on the follow-up, it says that the Global Refugee Forum, and the Global Refugee Forum is a forum where the 193 countries can meet and discuss, and this will happen once in 4 years. And the high officials of the countries will meet once in 2 years. And every year, the UNHCR has been asked to present the status of the refugees in the UN General Assembly. This is something good, we welcome. But at the same time, UNHCR only is involved in the preparation of the GCR, and the UNHCR is the one, which is holding, the GCR and the implementation of the GCR, and it is they who will be presenting. But what is, being left out here is an independent monitoring mechanism. Even including the work of UNHCR has to be monitored. If UNHCR is going to, have the GCR from the beginning to the end, they were the ones, who were responsible for the GCR process. But finally, if they are going to, for each convention, we have,
Excuse me, Dr. Bernard, sir. And I think there was some disturbance from your audio. Can you please check any other device is open over there and it is echoing since last few minutes?
Okay.
Initially it was not, but now last 10 minutes it's some echoing and fluttering noise.
Is it okay now?
No, sir, it is no. Yeah, we checked from our technical side also. It is not problem from our technical side. It is from nearby. There could be any other device. Now, can you start speaking, sir? I will let you know.
Okay. Yeah, about the Global Refugee Forum, about which.
Yeah, it is better now. I
Now
think,
it's
yes.
better,
Better
sir.
now. Okay.
Yeah.
So the Global Refugee Forum, about which I was talking to you, namely once in 4 years, the leaders meeting, and once in 2 years, officials meeting. And every year, the UNHCR will be submitting a status report to the UN General Assembly. When we look at as far as the one would definitely welcome it, and I too welcome it. But definitely, we need an independent body to monitor, what is happening to the refugees. For each convention, we have a committee, and that committee is able to receive reports from the stakeholders, from the state and also from the non-state actors. So in that way, we don't have an independent refugee committee here. This, I think, is a major lacune we see in the GCR. And if we can have a committee like that, then it will be easy for them to receive, the feedback and the problems of the refugees, and then to submit it to the UN General Assembly. Then you will have a report, and you will also have a shadow report, and that will give a balanced picture of the condition of the refugees or the status of the refugees in the world. Maybe I will stop here, and if any there are questions, then I will take it.
Thank you so much, sir. Thank you so much, and it's wonderful to lot of suggestions and a lot of inputs are given by Dr. Bernard Swamy from his experience, from his scholarship. We could see that very, very effective and contributive suggestions which we have got. And now, before offer any suggestions and my comments, now I would open the floor for these discussions and question and answers. I request our coordinators and organizing committee, if you have collected some questions, you can directly pose to the respective speaker.
Yes, sir. It was really good session and very informative. The first question to Surya Narayanan, sir, is it justified to have a refugee law in India as most citizens of India are lacking basic amenities? Professor Surya Narayanan, am I audible?
Yeah, you are.
Sir, this question is for you, sir.
Can you hear me?
Surya Narayanan, sir? Yeah, yes, sir. Now we can hear you.
No, I am fully in favor of a national refugee law. It has nothing to do with the standard of living of the people. I do not know how the questioner thinks that unless our living conditions improve, we should not have a national. There is no relationship between the two. And that's been pointed out by the other panelists also. Our not signing the UNHCR Convention or the optional protocol does not stand in the way of the enactment of a national refugee.
Okay, thank you, sir. There is another question for you, sir. Should we have a shared refugee law for South Asia, as the concept of nation state cannot be applied here because of civilization ties?
Question of a common refugee law at the present moment is impractical because of differences among. But we can have a national refugee law, and the other countries can also have it, perhaps modeling on what we have done. A common refugee law for all the South Asian countries, given the differences, various differences among member states, is today impractical.
Oh, thank you so much, sir. And one more question for you, Professor Suryanarayanan. How do you see the role of SARC in dealing with the refugee issues prevailing in South Asia?
Most of the refugees, we are in the receiving end of refugees from all other South, most of South Asia, except perhaps Maldives. So our way of looking at it is in many ways. There have been only 2 occasions, as far as I know, where government of India had denied refugee status. The first was in the case of Stalin's daughter, Svetlana. Svetlana was married to a Rajput, a relative of Dinesh Singh, former Minister of Foreign Affairs. He passed away in Russia, and she brought his ashes to India to be immersed in the Sangam. At that time, he wanted to take up Indian citizenship. In fact, the matter was raised in the Lok Sabha in 1967 by Dr. Ram Manohar Lohiya. The government of India, in its own wisdom, decided not to give her citizenship, because by giving citizenship to the Dalai Lama, our relations with China deteriorated. And if we give a positive answer to the queries made by Svetlana, our relations with Soviet Union will go. So she went to the American embassy, Roosevelt House. From there, they took her to Nepal and took her finally to the United States. She wrote a lot of books on the Soviet Union, catering mainly to the US needs. Made a lot of money, but I don't know whether she was happy. She passed away a few years ago. The other case where we had denied an asylum is in the case of Mohammad Nasheed, the Maldivian nationalist leader, who sought asylum in our High Commission in Mali in 2012. We did not give him, we threw him back to the wolves. Later, he went on medical treatment to the UK, and you know the rest of this. We should have given him asylum, and that's as far as I am concerned, but we did not.
Thank you so much, sir. There is a question for Professor Srinivas Bura. The question is, despite being the host to several refugee groups from the very beginning, what actually desists India from being a signatory to the 1951 Refugee Convention?
Okay. Thank you very much for the question. It's a very important and valid question. India takes several reasons, and if you look at them on a face value, probably all of them are valid reasons. Now, it says that, and it is a consistent position which it has been subscribing to for the last 60 years, 70 years, is that India does, the Refugee Convention does not specifically address the group situation where it is primarily focused on individual refugees rather than the groups, because most of the times the refugee flows are in large numbers. The other issue that it has objection is that it does not specifically take into consideration the concerns of the developing countries, which is also true. I mean, what India subscribes to. The third aspect is that it does not address the question of a mixed flows, that is economic migrants and the asylum seekers, which is also true. I mean, there is no denial of that. There are challenges with regard to the legal framework of the convention. The other most important one is also that the convention does not specifically focus on burden sharing issues, which is again absolutely true. So therefore, actually, there is no fundamental problem with India's positions vis-a-vis not becoming a party to the Refugee Convention. And that is the reason why some of the scholars like Chinni have insisted that India doesn't need to become a party to the, because there are certain challenges with regard to the convention, as well as challenges with regard to the policies or implementation of the same convention by the European powers. and that story was fine till recently, where India was not becoming a party to it, did not have or does not have the national legislation, but on the practice side, it was perfectly doing fairly well. However, the question of law and the policy, I think that is where the students of law would be able to appreciate it well, is that why we sometimes insist law has to be there instead of a mere policy, is that somewhere it brings with certain obligations. And when it violates it, at least there would be certain responsibilities that would entail. I think that is where the problem is now, that there is absence of international legal obligations, at least treaty obligations. There is a complete absence of a national legislation. So therefore, it is completely left for the policy framework. So there, I think, where that seems to be the case, that why people like Chimney are changing the opinion that even if there are problems with the Refugee Convention, probably it is better that India becomes a party now, because at least there would be some form of legal obligations for India tomorrow. It cannot get away from its obligations. Means it cannot reject the asylum seekers when they seek asylum in India. So therefore, there is fundamentally no problem with India's position historically. But the problem is only coming that there is absence of national legislation. So the point that can be argued now is that if you have serious problems with the Refugee Convention, no problem, but have some national legislation which can incorporate the positive aspects of the convention, but it can also incorporate your security concerns, because that is somewhere I think probably you may have. And also you can formulate a law in such a way that it makes a clear distinction between economic migrants and refugees. I think that is where we need to insist on that. Yes, thank you.
Thank you. Thank you so much, sir. As I can see, there is another question for you, Professor Burra again.
Yes.
What is the significance of GCR from Indian perspective, particularly when India is not a signatory to the May 1951 Refugee Convention?
Yes. Okay. So this is my personal view. My personal view is that GCR does not have a great impact or may not have great impact on countries like India. The reason why is that the GCR framework is predominantly addressed in a neutral sense, but predominantly to those states which are parties to it. See, for India, the most important aspect is that access to asylum. Now, that access part is completely missing in the GCR framework, the access part of it. Now, that is where Professor Chimney writes in the entire GCR, the right to asylum remains as a footnote number 5. Now, so nowhere the right to asylum is mentioned in GCR. It just remains as a one footnote somewhere in footnote number 5 for the GCR. And the access to asylum is a fundamental question for India, because GCR's predominant work is that how to involve multi-stakeholders, various other entities in a civil society. But that can happen only when the refugees are on the territory. The moment you prevent them from entering into it, there is no point in having an elaborate mechanism which would only be helpful when only the refugees and asylum seekers are on your territory. The current legal position is that in India, to a large extent, the right to seek asylum is somewhere curtailed. It's almost like there at the borders. So therefore, unless you allow them to enter into your territory, then we can talk in terms of how to really look after the refugees and how the burden sharing framework has to happen. So therefore, in that sense, this is completely my personal view, that in that sense, I think GCR does not seem to be having a major impact on countries like India, where there is absence of international legal obligations and also absence of national legislation. Thank you.
Thank you. Thank you so much, sir. These are the questions for Professor Sami, which we got it from a YouTube link. So, sir, the question is, how much assistance can states expect from other states regarding accommodation? Because some states have more refugees than others.
States, different countries? Yeah. Okay. I think the question has been addressed even earlier, that the mixed flow and then the not individual refugees, but coming as a big number, group and, in a huge number. That makes a distinction between the refugees of South Asia and others. So this is where when it comes to accommodation, within India also the treatment of the refugees is very different. Chakmas and Tibetans are treated extremely well when you compare with the other refugee groups. In that way, this is where I think I would agree with both Dr. Burra and Dr. Suryanarayanan that we need a national refugee law so that we can have the uniform treatment of refugees within the country.
Sorry, I was on mute. There are two more questions for Professor Burra, I guess. So the question is it obligatory in India to provide humanitarian assistance to ethnic groups of refugees?
I mean, in terms of looking at from the point of view of law, that is what we are trying to say. I mean, of course, it is like when you look at the word humanitarian assistance, it is a much broader term than the refugee, because the humanitarian assistance involves various other victims of conflict and other categories of humanitarian assistance. Now, each aspect is, to a large extent, is governed by a particular legal framework and national legislation. But so far as refugees is concerned, yes, at least I try to argue, that is what I try to present it, that it does have an obligation under customary international law, even in the absence of treaty obligations. So therefore, there is an argument to clearly put across to this Indian state that there is an obligation for you under international law, and you cannot completely reject the asylum seekers purely, and that is what is happening on the national security ground. Yes, national security ground is an important ground which is addressed by the Refugee Convention, and that is a concern for many other countries as well. Now, it is not something very specific to India. So therefore, I do answer it in an affirmative that yes, it does have certain obligations under international law to provide humanitarian assistance in some form or the other, because many countries did evolve their own domestic mechanisms. In fact, there is no temporary mechanism under the Refugee Convention, but many states evolved that mechanism also. So therefore, there are states which are experimenting with national legislation in terms of kind of making certain amendments or modifications to the global framework. So, but that is somehow is absent in the Indian context. Yes, thank you.
Sir, another question to you again. The question is, hundreds of Pakistani Hindus have migrated to India in search of security and citizenship, but are caught in a maze of rules and regulations that have left them stateless for years and years. So what's your take on this?
Okay. See, I mean, we don't need to make it, once we get into the identities part of it, that is where somewhere I think abstract legal categories sometimes are helpful. I'm not always helpful, but most of the times abstract legal categories are helpful, because many a time we try to bring in identities, like in the subcontinental context. The religion becomes an important one, the memories of partition, the pains of partition, and their contemporary relevance makes it messy. Now, if you go back completely at an abstract level of subscribing to certain fundamental categories of granting refugee status, whether it is a Hindu from Pakistan or a Hindu from Afghanistan or Bangladesh, or some other category of Muslims from Pakistan, Sri Lankan Tamil refugees, now Rohingya Muslims. Now, all of them somewhere are adequately addressed in the legal framework. So therefore, the moment we subject them to political priorities, I'm not against politics, but subjecting them to political priorities, somewhere we need to make a fair distinction between certain legal obligations and certain political priorities of the governments. So therefore, I think every government will have its own political priorities, but somewhere we need to put an end to that. And yes, there are certain international law obligations we need to respect. Now, with regard to the specific question that you posed, if there is a problem with statelessness issue, which of course is there very much, that is where the options of the law is a problem now. So we need to have somewhere the comprehensive national legislation covering these aspects. There is a complete absence of national legislation addressing these questions with regard, of course, they are closely linked to the citizenship, but they are significantly the questions of refugees, that is asylum seekers, and the questions of statelessness, which need to be really addressed in that sense. Yes.
Thank you so much, sir, for all of your answers. Thank you so much to all Suryanarayanan sir, Professor Bernard Swamy, and Professor Srinivas Burra. Thank you for your answers.
Thank you so much, Mosmi, for putting a nice questions, and also all the speakers who are given very good orientation towards the protection regime and protection mechanisms. We have seen from the practitioners' perspective, we have seen from the legal perspective, and also we have seen from the academicians' perspective in this particular session. So I feel that this is one of the most useful sessions, and the suggestions and comments which have come from this particular sessions are very useful. And also the points which we could see Srinivas has argued that customary principles of international law is binding on the obligations of the state, even though you do not have the law to the 167, but still we have very good legal framework. That's what even sir is also now talking about this of the national security, etc. No, reminding ourselves about. I think we are very well within the time, and we could able to conclude this important sessions, as we have scheduled. And thank you very much, to all, particularly the speakers, those who have spared their valuable time within the short span of time and a short notice. And we profusely thank three of them on behalf of UNHCR, on behalf of TIS, and also on behalf of VITAP School of Law. It is a wonderful session. Thank you very much. And now I hand over to Dr. Pari for his few remarks. Thank you.
Okay, thank you very much, Professor Banerjee, Professor Suryanarayanan, Professor Bernard Swamy, and Professor Srinivas for a wonderful opening session, I should say, for laying the foundation of this webinar, and so much of legal, political, and policy perspectives have emerged well. Thank you so much. Now, one general announcement to the participants that we have posted a session-wise your feedback link. So kindly fill it up. It is already there. The link is available in the chat box. Kindly fill in your comments there. And then we are closing now sharp at 12:59. That is just a minute before 1 o'clock our deadline. I think well managed so far. But I think the afternoon session is quite bulky. We have to start sharp on time at 2 p.m. So all the participants can remain to be connected here and put yourself in mute, and you can just continue. Or if you want to log out and come back, let us see, because morning we had a tremendous pressure that it exceeded that 100 limit, and many had to be advised to go to YouTube link. So if you want to continue, you continue. You want to log out and come back, come back. We thank you all again, the panelists and chair, for this, and we will now go for our lunch break and resume at by 1:45. We all can resume back a login, and then sharp at 2 we will start the afternoon session. Thank you very much to one and all, and to all the participants for wonderful questions. You have been continuously posting even now questions. We are taking note of it, but we will be able to connect with the respective resource persons and get back to you probably in the afternoon sessions. Thank you very much. Continue to be proactive. Thank you so much. We'll have our lunch break. Thank you.
Yeah. And this will remain open for your attendance and feedback, and kindly fill that your attendance, and all the participants will be given the